Andrea. We can go live now.
Hi, good morning, everyone, and welcome to the second Children's Commission meeting of 2025. Happy Friday, happy May. I'm so glad to see each of you joining us from your offices, homes, or wherever you may be today. I'm looking forward to seeing you all in person for our next meeting in September, but today, for our spring meeting, we're going to use this format to meet at a slightly in a slightly less costly way, hopefully a slightly more efficient way. And even though we'll miss being together in the same room, the idea is that we will keep our work moving forward and continue to share our important ideas about the Commission's work. So before we dive in, I want to say it's always great to meet with dedicated people like every person on this call from all across Texas who are committed to strengthening the child welfare system and supporting Texas families and children. So I look forward to a productive discussion today, and I want to thank everybody here for making time to participate today, and also for all of the work that you do each and every day to support Texas children and families. A word about today's meeting. Your feedback, of course, is really important in shaping what the Commission does each year, and we want to remain focused on critical issues in the child welfare system right now. So our primary goal for today's meeting is to review ideas that the Commission staff, in consultation with lots of folks on the Commission, on the Collaborative Council, have come up with to be our primary ideas for projects for the upcoming fiscal year. And to get a conversation going during our time together today about whether those projects are on target, whether they hit the mark, whether they are responsive to the issues that need to be addressed, because we want to be sure that we are focusing our efforts appropriately and looking and working and addressing the right issues. Before we dive into that, just a couple of quick housekeeping matters. So our meeting today will end no later than 11:30. We want to be mindful of everyone's schedules, and we won't take any breaks. If you need a break, please feel free to take it. And if you step away, just remember to shut off your video if you're able. And if you're not speaking, keep yourself on mute to make the audio optimal for everyone else. Committee and Collaborative Council members are participating in listen-only mode. And we're broadcasting the meeting live on YouTube. If you should want to interject, the question and answer function is available if needed. Now, let me give a quick overview. I've talked about what the focus of today's meeting is going to be. Let me just give an overview of how we're going to run the meeting today. I'll have some membership change announcements. The meat of the meeting, as I say, will be on planning for projects for the upcoming fiscal year. We'll want your involvement there to ensure, again, that we're hitting the mark in terms of where we need to focus resources and effort and time. We'll have an update from the DFPS, and we'll have an update also from OCA. I think Megan Lavoie will join us for an update from OCA, and also hopefully to give us some updates on what on legislation that is within our realm of focus. And then we'll close with some announcements from Collaborative Council members. So let me first go to membership changes. So you have a meeting notebook, and behind tab 1, you'll see there's a sheet that identifies Commission, Committee, and Collaborative Council membership, as well as staff. There are a few changes I want to highlight today. So Carla Baker, along with Justice Partita Kipnis and Justice Julie Countess and Sasha Roscoe. So those 4 women have rolled off the Commission. We're grateful for their service, and we have acknowledged their service by sending a certificate of appreciation to each of them. I'm excited to announce that we have a new ex officio member, honored to have Representative Lacey Hall appointed to the Children's Commission earlier this week by the Speaker. So Representative Hall is the chair of the Human Services Committee, and we very much look forward to her involvement with the commission. Representative Hall, not to put you on the spot, but welcome. And if you would like to, I'd like to invite you to say hello and share whatever thoughts you have about the commission with us.
Well, thank you all. It's an honor to be here, and I know I have big shoes to fill. Stephanie Click is incredible, and so I know I'm taking her spot in the House. And I deeply care about child welfare issues and legislation. I've been on Human Services the entire time I've been in the legislature, and youth health and safety before when that was a committee. And I just very much look forward to being part of this. Really grateful for this opportunity. And yeah, I know that several of my bills, I'm sure, are big topics of conversation, including ICWA. I truly believe it is important that all Texas families have the gold standard that Native American families have as well. And I know many states across the country are looking at Texas, and I think it's incredible, and just really appreciate the opportunity, and excited to see what comes from this and the future meetings, and looking forward to meeting everyone at I think it's the September meeting. So, and I see Audrey, so I know Audrey, but I don't know that I have met anyone else on here. So looking forward to meeting all of you soon.
Well, heartfelt welcome. We're delighted to have you, and look forward to having your valuable input and insights for our work.
Thank you.
Okay, next, Catherine McAnally is joining the Systems Improvement Committee. Ms. McAnally is an attorney who practices in Central Texas, and she brings experience representing children, parents, and the state. So please join me in welcoming her as well. We look forward to working with you. And then finally, we have a staff member change. Amy Corbin is no longer with the Children's Commission as a staff attorney. She has transitioned back to the courtroom and will be in private practice in San Antonio. Everybody knows Amy contributed much to the Children's Commission projects over the past nearly 5 years. We will miss her, but we'll look forward to her future endeavors and with working with her in this new capacity. And Jamie Bernstein, superhero, will be handling Amy's projects until we can fill the gap there. Okay, so that brings me to the end of membership and staff changes. Next item of business is to tend to our minutes from the February 7th meeting. So those are at tab 2 in your notebook. If you're looking at the digital version, that's page Roman 10 in the PDF. Everyone, I hope, had an opportunity to review the minutes. And I will welcome any corrections, any further input folks have on the minutes rather, of the last meeting. Anything to comment or add? Okay,
Move
is
to
there a
accept the
motion?
minutes as proposed.
Wonderful. Thank you, Judge Ferguson. Anyone second?
Yes, I'll second that motion.
Thank you, Judge Stuckey. All in favor of approving and adopting the minutes?
Aye.
Show your hands. And thank you, everybody. Anyone opposed? Okay, the minutes are adopted. Now, if you are looking at the physical notebook, we will turn to page 3, arriving at the meat of today's meeting. If this is comprehensive details on each of the Children's Commission projects. And what I'd like to do now is turn it over to Jamie Bernstein, our executive director, to introduce the conversation. I know she has a plan to have the conversation in several different categories of projects. So Jamie, why don't I hand it over to you now?
Thank you, Justice Huddle, and hello, everyone, and welcome to the meeting. I also want to echo Justice Huddle's welcome of you, Chair Hull. We are so happy to have you and wholeheartedly welcome you to the Children's Commission. I really look forward to working with you and partnering with you. And I also feel, I must mention, the fact that you are here today means so much to us. I know it's an extremely busy time for you, so appreciate your commitment and making the time to join us. I know you might have to jump off at some point, but we're grateful for your time. So the commission report that you have in your notebook is retrospective from the last meeting to now. And what we're going to spend the lion's share of our time today on is the fiscal year 2026 planning. So we're at that planning season where we're halfway through this fiscal year and we're starting to think towards next year's goals and objectives. As you know, we have 4 standing committees, how we organize our work, systems improvement, legal practice and process, training, and data. And we think those are the 4 pillars of our work, in addition to collaboration, which I'll talk about in a second. Each of those standing committees met in anticipation of this meeting. And what we're doing today is elevating the feedback that we received from those committees for your review and discussion. The big picture goal is to take that feedback from the committees and from you all today and to synthesize that into an updated strategic plan and to come back to you in September with that proposed slate of activities and the accompanying budget, because of course we need to be able to put money behind the efforts that we're proposing. So as a result, I just really want to emphasize that your feedback is very important to us. I really encourage you to jump in verbally with questions or through the Q&A feature. But of course, if that's not your style and you want to think about it, please contact anyone on the team. But I encourage you to contact me directly with any feedback as well. So with respect to the collaboration goal, it's our plan to continue these 4 strategies into fiscal year 2026. So I'm not going to spend a lot of time discussing them other than to say that collaboration is the foundation of everything we do at the Children's Commission. We would take the whole meeting if I listed all of the partnerships that are required in this work, but this is something that is very much a joint endeavor, and I firmly believe that we are all partners in this work to strengthen the child welfare system. So this also includes in this area of our strategic plan a commitment to making all of our resources, trainings, and guides available free of charge to judges, attorneys, and anyone else who's interested in our website or other communication mediums. I've mentioned before, it is our goal, and I anticipate we'll be able to do it sometime between the end of this year and the beginning of next year, is to make our website more user-friendly to parents and youth, to make sure that those resources are streamlined in a certain way. So that's something that we're actively working on. I will move on then to the systems improvement goal and the strategies that we discussed in that committee meeting. And Judge Hoffman is our chair, so always grateful for his leadership. So I'm going to pull out 3 strategies that were discussed in more detail. The first is strategy 7, which relates to youth engagement and normalcy, and the inclusion of people with lived experience in systemic improvement efforts. What the group talked about was perhaps looking for more opportunities for youth and young children, youth, and young adults to be involved in the child plan of service process, either through the more involved in the CANS assessment or more involved in the development of the child's plan, and just really wanting to understand better what the attorney ad litem's role might be in that, how they can encourage the child's voice to be a bigger part of that process. So that was the first idea, was to do some exploration about maybe some attorney ad litem training or looking for opportunities for them to get more involved in that process. The second is strategy 8, which relates to prevention and family preservation. And what we talked about was maybe expanding this category to do a little more emphasis on reunification and seeing what can be done through the legal system, through attorneys and judges to really strengthen emphasis not only on prevention and family preservation, but also on reunification. Another idea that members talked about was perhaps looking at other outcomes. This is not something we've talked about historically at the Children's Commission, but emancipation or Chapter 34 or Chapter 35 authorizations. It's just a space that we haven't considered before, so that was something that those members brought up as of interest. And the last thing I'll say is that they talked in this strategy about refusal to assume parental responsibility allegations and what can be done in the legal community to maybe support better outcomes in those types of cases, and especially when the allegations relate to a child's unmet mental health need. So that was an area of interest for that group as well. And then strategy 10 is with respect to what we call kind of children with specialized needs. This year, the focus in this group is on children who've experienced sexual abuse, and we're partnering with the governor's office on a Know Your Rights document for caregivers to really understand what the law is in this area. We talked about, for the coming fiscal year, talking about medical cases and the Forensic Assessment Center network, and maybe additional training that judges and attorneys might need in those types of cases. We also discussed children with very specialized needs, like those who might be eligible to be on an HCS slot, and youth who receive SSI payments and the issues related to that. The last thing discussed in this strategy was supportive decision-making and maybe the development of some kind of training or resource guide. And I said there were 3, I'm sorry, there are 4. We also talked about roundtables, which is strategy 11. And we are tentatively planning to hold a roundtable on caregiver engagement in hearings. That's tentatively scheduled for November 2025. The discussion will center on ensuring that all parties and caregivers have proper notice for hearings, but we're also interested in the hearing quality of what happens when they come to court. But the issue of the notification was identified as an area of need of improvement in the Federal Child and Family Services Review. So we're hoping to launch that work with a roundtable meeting in fiscal year 2026. And I'll note that it's anticipated that the strategies related to the Juris in Residence, the Consortium on Trauma-Informed Care, the intersection of foster care and education, and placement capacity will remain largely unchanged. So that's why I didn't discuss them. And I'll note that the dual status and juvenile work is largely dependent on the pending exceptional item request that's under review by the legislature. So we're not sure what that work's going to look like. We'll see if that request is granted or not, and that'll impact what direction we go in that regard. But I will stop talking and pause to see your input and your ideas about any of those things. And just at a high level, so the first was youth engagement. The second was family preservation and reunification. The third was children with specialized needs. And the fourth was a roundtable on caregiver engagement. So any feedback is most welcome. Any thoughts or ideas?
So I have a question, Jamie, before we hear others' thoughts. I wondered, could you say a little more about some notice problems that the federal reviewers identified in terms of getting caregivers notice of hearings? And could you say a little more about what those hearings are like? Are we talking about hearings sort of after a removal but before a termination? Or are we talking about just kids who are in the foster system for the long term, or what sort of hearing? Could you give some context to what that
Sure,
means?
that's a great question. So as part of the CFSR process, I was very fortunate that the department included me every step of the way, and I was able to sit in on the stakeholder interviews with over 200 people statewide. Different audiences were asked the same questions about who notifies caregivers of hearings and what is in the notice. And for almost every audience that we asked, we got a different answer. So, and by we, I mean, the whole process. So, it was the DFPS caseworker, it was the SSCC caseworker, it was the prosecutor, it was, hearing it in open court. So there's great variance throughout the state. And typically it was just the date of the next hearing. But sometimes, rarely, it was you have the opportunity to be heard at the hearing was included in the notice. So it's really unclear what the caregiver is being made aware of. And then what are the expectations when they come to court? Will they have an opportunity to provide input about how the child is doing? And there was some information at the end about, not being clear how much information could be shared depending on whether they had intervened in the case. So I think those are some issues that we thought a roundtable would be really helpful to unpack of, how is this working throughout the state? How do we want it to work? And how do we get it to be more uniform. And I'm sorry, what was your second question? That was the
No,
genesis
I
of
mean,
the
you're
problem.
answering the question. It actually comes as something of a surprise to me that a caregiver wouldn't be on the court's list of parties to notify of any hearing upcoming in the case. And it strikes me as odd that we would rely on the department to give a caregiver notice of a hearing. I'm sure there are plenty of reasons folks on this call might know why that, is done that way, or why it wouldn't make sense to just give notice to the caregivers of any hearing. But that strikes me as something that's odd, maybe not, entirely reliable, and something worth considering in a round table or otherwise.
Yeah, Justice Huddle, I'll speak to that. Typically, it is somewhat unusual for a caregiver to be present in a court hearing, although they are allowed to have legal notice. And with the significant amount of changes in caregivers throughout the life of the case, the court may not always be aware of who the caregiver is. The department, of course, has more updated information on that. And so the communication between the agency and the court, I think, probably is where the problem would occur. So generally, the department's going to have better information about that status.
That makes sense. And I guess I was thinking that that there might come a time in the process where that settles right after there's a sort of a long-term or a permanency established. But early on, I can imagine there's a lot of transition, unfortunately.
So Jamie, are we talking about, I'm sorry, my computer froze. Are we talking about statutory hearings or special status hearings? Or because one thing that we've done to address that issue, as well as just notice in general, is we do a scheduling order. So we give them the dates of every hearing on the after the adversary hearing, the show cause hearing. So we give dates for all of the remaining hearings up until the trial date. So are you talking about special status hearings that aren't statutory, or just any hearing in general?
I think in large part it's the statutory hearings that's not happening consistently across the state.
Okay, certainly I didn't mean to hijack and get into the weeds on one of the very many big ideas you mentioned, Jamie. So thank you. I think it sounds like that a roundtable on unifying how notice works might be a good project to take on in the coming year. But I don't want to hijack the conversation because Jamie mentioned lots of bigger picture ideas. So let's focus there.
Well, Justice Huddle, I just wanted to say it's great to be back with you. Although I've been absent as NCJ SCJ president this year, I have attended all the Systems Improvement Committee meetings, and I want to thank those members of our committee that have worked really hard this year who are present here with us. And just highlight a couple of the things that Jamie said. Prevention is such an important focus for our work, and I think we were very excited to talk about training for attorneys appointed to represent parents and additionally children in prevention circumstances. So that's something I think we'll be focusing on the front end, like Jamie discussed, and then also maybe a little bit in the weeds, as you said, Justice Huddle, talking about specific children. The population isn't great, but who are available for HCS slots and as Jamie mentioned, with SSI payments, and sometimes the terrible decision that courts and advocates are having to make between taking a child out of an HCS slot, which they'll be eligible for post 18, and placing them. So there's a lot of good work to be done there. And it seems like as our overall state population of children in the program decreases, those cases become more and more prevalent for us. I certainly have had more and more of those in my court. So on both ends of the spectrum, the beginning of the case and the end of the case, we have a lot of good work to do from this committee. So again, thanks to all those guys here on the committee that worked hard this year.
Thanks, Judge Hoffman. Could I ask you to, for the benefit of me and maybe a couple other people on the phone call who don't know what an HCS slot is, could you say a bit more about that?
Right. So, let's see. Someone's gonna have to remind me what HCS stands for. Jamie, what's the acronym?
Audrey, do you want to jump in and explain
Sure,
that from
it's-
your perspective?
Sure,
I-
it's a home and community-based care waiver slot,
Okay,
which is a
okay.
Medicaid waiver program.
So the issue is sometimes when children age out and are adults but have to be in permanent placement, they are eligible for an HCS slot. And thank you, Audrey. And the waiting list is very, very long, years even for those slots. And so sometimes we have kids in permanent foster care who we know are going to be needing that after 18 HCS slot on the list, and they make a placement in the HCS home. And every once in a while, there's an issue with the disruption in that placement or a relative that's identified. And it's tough for the court to have to decide if a child is about to turn 18, do I pull them out of that HCS slot and place them somewhere else because they'll lose their status? And so we do have a lot of HCS placements that will carry over post 18. And like I said, it's a little bit into the weeds, but I think we need to do some work and coordination in that other silo, as well as SSI, to get that coordinated. The department does a good job of having liaisons, but help judges be able to make an easier decision of moving kids around without losing their HCS status. I hope that explains it. Audrey could probably do a real good follow-up for me as well.
I think that's effort. That's accurate. I will just note that the department is really focused on some changes in HCS slots. There was a period of time where we used HCS slots, possibly, we'll reuse them more frequently. And we have really pulled away from that and are focused on really only using HCS slots for children who meet that waiver qualification, because we really want to make sure, just as Judge Hoffman said, it's a long-term solution for those kids. It's a very, very technical process. And I mean, I think some education and process looking around this is absolutely a value add for the system as a whole. And we would be more than happy to partner with you on that. And we can also share, I mean, through that process, I think we can share some of the internal process changes that we have here as well.
Dr. Blau, your hand's up.
Hi, thanks. Good to see everyone today. And I think this has been a great committee and a good report out. I appreciate that. And I think that these priorities and things are the areas of focus are critical going forward. I would mention just one more potential sort of a strategy, maybe not for the report, but just for the committee or the council to think about would be perhaps engaging with HHSC or the Juvenile Justice Department at TJJD to talk about the idea of sort of a cross child serving agency, system of care approach there. While there are changes going on, of course, in the federal government and my former agency, that there's still many opportunities ahead. And this may not be in this particular fiscal year, but going forward, I think that there'll be opportunities under the federal systems of care grant approach that Texas could really be, I think, well positioned for around some of the needs to address some of the mental health and other issues that are in child welfare and those populations. So I just throw it out there as a strategy, a potential way, as we're doing either roundtables or meetings, to engage with the leadership of those departments and talk about how there could be some better ways to integrate our work and facilitate, a better communication and working relationships across those departments. So money is usually a good way to help grease some of those wheels. And if there's a way to get some federal dollars to help Texas do that, I think it's something to consider.
Thank you, Dr. Blau. That's great feedback.
One thing I think I would like to know for myself, but also that I think that might be a benefit for folks across the board on the call, is if you might say a little more about what the conversation or thinking is around increasing work on reunification and what that might look like. I think I understand pretty well sort of the tangible sort of Know Your Rights project, right? I can envision what that's going to look like, and also what youth engagement throughout the process, increasing youth engagement looks like. I can't quite envision what some of the thinking or ideas are around reunification. So be happy to hear more about that from you, Jamie, or from anyone who's had it on the brain.
Well, I'll say we're already starting this work. We have DFPS is about to do their second reunification conference this summer, and we're trying to help them find some judicial speakers. But in June of 2025, in about a month and a half, we're going to do a webinar on reunification. I think that's a good starting point to kind of begin to unpack this about what attorneys and judges can do throughout the life of the case, before, during, and after reunification, to support the family. But there could be more, and I think there probably is a lot more that we could do, and I think we would get together a group of subject matter experts to help us identify what that looks like. Is it more training? Is it development of some kind of resource? Is it working on a policy issue? I'm not exactly sure, but I think there is an appetite for doing more and creating more urgency, because as a state, we've been stuck with about a third of children reunifying with parents historically, and we want to help move the needle on that. So what can we do as the Children's Commission to raise practice in the legal system to promote that outcome in our cases? So we just think there's more that we could be doing, and we wanted to see if this was the right space for us to identify a project. I don't know if that answers your question. It's not fully baked yet, but we know there's more we need to do.
Sure. Sheila, do you have something to add? It looks like your hand is up.
Yes, I just have a question about reunification. And just to maybe, if it's not on the radar, to put it on the radar. I'm wondering if that process might include or could include youth alumni. Because oftentimes, the person who would be most impacted is not often the person who's included. And so my question is, youth alumni who have either been through the process or may have ideas about what they would have needed had they gone through the process, might have some really wonderful ideas about and input about how that, what critical pieces might be important as you take on an initiative like that.
Thank you, Sheila. That's a great point. It would not be possible to do this work without the voices of people with lived experience. So I think having young adults at the table and having parents also with experience at the table is absolutely critical if we're going to do this work. Okay, well, I think we should move on to legal practice and process, but again, please contact me or anyone else on the Children's Commission team if you have more thoughts on these systems improvement strategies. With that, I'll turn it over to Renee and Brenda to talk about legal practice and process.
Thank you, Jamie. The Legal Practice and Process Committee met on April 25th to review the slate of projects proposed for next fiscal year from its various work groups and committees. And we have 4 areas of focus that we have identified to really look at for next year. I'm going to discuss the first 2, and then I'm going to pass it along to Brenda to discuss the last 2. So the first of those is hearing quality. And this could take the form of a work group. Issues to focus on identified by the group are evaluating the appropriateness of permanency goals. I think that it was mentioned that sometimes throughout the life of a case, the permanency goal may have changed, but it has not yet been reflected through court reports. And so just ensuring that those things are matching up and that we're still working towards reunification, if that is the goal, or if things have moved towards something other than reunification, that has been articulated and the family has been made aware of this, and that we're able to identify and maybe work on those steps as to what needs to be done next. Then the next thing is maybe identifying ways to be more diligent about locating family, and this includes the paternal side of the family. It's been mentioned that a lot of times the father is not present or has not been located early on in the case, and this sometimes starts it delays the reaching out to the paternal side of the family, and that is a whole other side of the family that the department and everyone can be talking to with regard to trying to find appropriate placement or stability for the child. And so we want to focus on making sure that locating happens sooner, and then also trying to get them just involved in the process. Many times these fathers who are not able to be found early on may not have been involved with the child's life for various multitude of reasons, and it's just trying to get them involved, getting them to know what their rights are, and so that they can hopefully be able to be involved in that process to provide better options for that child in care. We also want to consider a focus on status hearings and the review of a service plan to ensure that it's more narrowly tailored to meet the child and the family's needs. The second area of focus is parent representation issues. Several of our work groups, including our parent resource work group and our mediation work group, have identified a need to do some additional training about representing parents. In particular, both have mentioned that they would like to do some sort of training regarding representing incarcerated parents. And so we are going to work towards collaborating between those two work groups to create a webinar that will focus on best practice tips for representing parents who are incarcerated. And this will also include a mediation piece about what you can do when your client is incarcerated and you are at that point of mediation. We will also complete the parent voice video project that we had started working on last year. There were some areas identified that they would like these videos to focus on, including what to expect at your first hearing, identifying all the players and what their roles are, caseworker duties, parent attorney client relationship, and of course, parents knowing their rights. With the changes going on in the legislature right now, we do think that this is a great time for us to kind of reconvene and think about if any of these topics need to change or what information would need to change in it. We will be identifying hopefully some lived experience parents as well as some attorneys to help us with the creation of those 3 to 5 minute videos that will complement those youth voice videos that occurred a few years back. And then finally, some trifold brochures that would help explain safety plans and parent-child safety placements. These would be something that's available to attorneys to be able to hand out to their clients, or maybe even DFPS to hand out to parents who they be in contact with, so that it can help explain just a little bit better what those opportunities are for them for safety planning and parent-child safety placements. It would be kind of just the one-page trifold that we've done, for example, with our representing the duties of attorneys representing parents or duties of attorneys representing children that we've done, as well as the pamphlets for fathers' rights. So those are the things that are focusing on for the parent representation issues, and I'll pass it on to Brenda to cover the last two.
Thank you, Renee. So the Legal Representation Committee is really focused on pre-petition legal representation in CPS cases this year. We are finalizing a statewide survey to help develop a shared understanding of what the representation currently looks like and what the various stakeholders envision for the future. So once the results of those surveys come in, then we're going to analyze those results, and the committee plans to work towards resources that will kind of assist in this area, such as an implementation guide. So we know that pre-petition work is something that has garnered a lot of attention and is very important for our families. And so the LRC is very closely looking at that and working with that issue. The Standards of Representation Committee will continue to develop a framework for Texas Standards of Representation. The committee currently has a goal of completing the standards for children's attorneys in fiscal year 2026. And then once we've completed the guide for attorneys representing children, then the focus is going to shift to attorneys representing parents. This has been a committee that has put in a lot of work over the past couple of years. And it is very focused, and it is very committed to providing the best standards that possibly can be. And so, yes, it's taken a bit of time, but the result, I believe, will be, you'll be able to see the result and you'll understand why it's taken so long. And I know Judge Ferguson has played a pivotal role in bringing that committee to life and keeping us focused. And so I'm back to Renee.
Thank you. Well, and then just finally, while not completely new, we just wanted to let everyone know that under the LPP committee, the commission will continue to maintain its various guides and projects that we create as deliverables, including but not limited to our bench book, which comes out every October. We are already looking at that and starting the editing process and review process for that. Both of our toolkits, the one for the attorneys representing parents and children and the toolkit for attorneys representing DFPS and child welfare cases, will also be updated this fiscal year, upcoming fiscal year, and will hopefully be distributed starting in March of 2026. And then the pre-litigation guide that we've been working on, we'll hope to have out this year, as well as updates to the parent resource guide, which was last updated in 2020. We tentatively have plans for the LPP committee to reconvene in July, just to take stock of any changes that have occurred during the 89th legislative session and determine whether there's a need for any additional work groups or projects to address any of these changes. And that is our LPP committee update for you today. Thank you.
You all have any reactions to those ideas? Any thoughts? Have we hit the mark? Does it seem like the right focus?
So I have a very strong and very favorable reaction to one of the items, and that is looking at family service plans. This is something the court, our court has written on, and sorry if this is getting very technical and maybe only sort of something the judges are able to follow, but I think it's important for DFPS too, because I would love for there to be a focus on where these family services plans come from. What is there a standard template? Are they promulgated by the department? Who is really looking at what that looks like in the very first instance? Is the end user, the judge who's actually signing off on the family service plan, doing a second level of tailoring to get at some of the issues that the Supreme Court has indicated in its decisions need to be refined and improved. And so I think that is absolutely, I would like for that to be a priority and undertaken, and probably there needs to be some work in terms of building a better template, and then in terms of judicial training, in terms of sort of whether that template fits or doesn't fit a particular case, what should be done to modify it and how that ought to be done. But that is, from my vantage point, I'm not boots on the ground on these cases, and so I welcome other folks to talk about what an ideal would look like. And here's Judge Stuckey.
Yes, Justice Huddle, thank you for those comments. I think those are all things that we wanted to look at as a part of that committee. Service plans can come from the SSCC workers. They can come from what we call our legacy system with DFPS. A lot of our plans are developed, we hope, in family group conferences with the parents and their attorneys, with the department. Sometimes those people aren't around. So as a judge, it makes me smile when you talk about these things, because these are important to us and it's important to our committee. So we are, I think this is something that we can do a lot of great work on over the next year.
Audrey?
I'll just add that, this timing could not be any better, and I'm so excited to hear this. We actually had reached out to Jamie to talk. We have some initiatives going on around family engagement, partially related to some current legislation, but partially because we see this as a really, really important area of focus for the department going forward. And the very first thing that we talked about is family service plans. And actually, Jamie sent us some really great sort of model plans that our teams are starting to look at. But I don't think I necessarily have all the information about the judicial concerns around the sort of the template for those family service plans and that. So I certainly will rely on Jamie and this work group to sort of inform our understanding, but we are going to be taking a very hard look at family service plans in the coming months. So I think that the timing for this is really excellent. And Jamie, I don't know if you want to add anything to that, but it's good. It's a really great topic for us right now.
It would be an honor for us to try to create the space for that dialogue and have the conversation. I think the time is now. So thank you, Audrey. Thank you, Justice Huddle. That was great feedback. Okay, any other feedback before we move on to training? Okay, Milbury and Renee, the floor is yours.
Thanks, Jamie. Good morning, everyone. The training committee convened on April the 17th to discuss potential projects for FY 2026. We had a wonderful, very productive discussion. And based on feedback from our members, the training team plans to focus on two main areas in fiscal year 2026. We'll be developing the priority training topics suggested by training committee members and figuring out how to increase engagement on our legal training support and judicial scholarship opportunities. So I'll start with the priority trainings and then turn it over to Renee to talk about the legal training support and judicial scholarship. So the top three training areas identified by our training committee members for FY 26 are representing parents, supporting youth with behavioral health needs, and special immigrant juvenile status and immigration. So I'll talk a bit more about each one. Representing parents. Several training requests converged around this topic. We had specific suggestions on training around how lawyers for parents can engage more with clients, department responsibilities in setting up services and paying for services, and how to remove red tape so that parents can access the services they need to succeed in reunification. The second topic is supporting youth with behavioral health needs. And this topic emerged as a theme across many training committee member requests. The suggestions were train on how stakeholders can use a trauma-informed perspective to work with youth who have behavioral concerns. And using this perspective, collaborate in order to address and prevent children being without placement and examine runaway issues. We also heard from the members that they wanted to see a training on how to engage with youth in order to discern what their concerns are in an effort to stabilize placements and prevent placement disruption or dissolution. And finally, the third priority training topic was SIJS, that's Special Immigrant Juvenile Status and Immigration. So this topic came up through several committee members, and specifically the questions that they would like to have us address are, when does the SIJS process begin? And what should judges and attorneys in state child welfare cases be aware of when it comes to immigration matters? So we plan to develop training in these areas at a minimum to be responsive to the needs in the field as identified by our training committee members. And we're also examining how we can train on the other topics that they recommended. And on that note, I'll hand it over to Renee to talk about our two new methods of providing training.
Thank you, Milbury. So one of the other things we discussed is how to best get out the word about these two new training opportunities that we have created. We had shared ideas with the commission staff on how to promote these two newest training opportunities. And the first is our legal training and support opportunity, and the second is our undesignated judicial scholarship. We've had challenges on how to get out the word about this to our attorneys, judges, and child welfare partners so that they all know about these opportunities that are available to them. So the first being our legal training support opportunity. If you'll recall, last year, we moved the Commission's Assistance to Local Jurisdiction Strategy under the Training Committee, and it has taken the form of this legal training support opportunity. Under legal training support, individuals who are seeking either technical or financial assistance with creating a legal training related to improving the safety, permanency, or well-being of children and families involved in child welfare cases can apply for assistance from the Commission's legal training support team, whether that be helping with agenda setting, identifying speakers, locating a venue, or paying for MCLE fees. And so this is an opportunity that we announced back in February. as well as also announcing the judicial scholarship that we have available, which is an offer of financial assistance to judges who handle civil child welfare cases in Texas in order to attend recognized trainings related to child welfare. This scholarship covers reimbursement for the conference registration fees and is an opportunity that was designated for trainings which are not already addressed by the Commission's scholarships, such as the Child Protection Law Scholarship or the NCJ-FCJ scholarship for the conference attendance. These opportunities, as we said, were announced in February. We've had little to no interest so far. However, there were some suggestions that were made by our committee members, which included resending out the resource letter announcement of these two opportunities, sending these out more regionally and directly to our judges or administrators, promoting this on our website, and adding maybe a testimonial from a judge who can share the positive impact that one of these two opportunities has had on them. Staff ideas have included creating a sample application to encourage questions about the process and maybe an FAQ section, or creating how to use this resource or how to apply video. We are currently in communication, though, with 3 potential legal training support opportunities since we had let out the report. And so there are actually interest from 3 areas in Hidalgo County, Grimes County, and Nueces County. Commission staff has scheduled to meet with them further to discuss the interest that they have in this legal training support and to answer any questions that they might have. We are going to also help them work through the application process that they would like to continue to seek that assistance from us. We're looking forward to another year of producing robust trainings through our in-person and virtual trainings, our webinars, and our podcasts. And we are always happy to hear back from you about what you identify as some training needs for our stakeholders. And with that, I will hand it back to you, Jamie.
And I'll open the floor for dialogue on these ideas and suggestions from the training committee. Okay, I'm assuming no comment means that sounds great. If you feel differently, as I said, please contact Milbreach and Renee. They are incredible assets for the Children's Commission team. So, you know, we rarely have a conversation where the word training doesn't come up. So they're integral to all of our work, and training the attorneys and judges throughout our state is absolutely critical to our mission. So with that, last but not least, Brenda's going to walk us through the data strategies.
Sure. Thank you, Jamie. The data committee met on April 15th and really served as like a think tank for the Child and Family Services review process, which you guys heard us talk about, the CFSR. We are working in partnership with DFPS. The data committee reviewed data received from 2 specific highlighted items, 2 items that were highlighted by the CFSR as areas in need of improvement, and which related to permanency and the courts. And we've already heard about the necessity for quality hearings, right? And so this kind of falls in that line. And those 2 items are the appropriateness and accuracy of the permanency goal and the timely achievement of permanency. How long is it taking for our children to achieve, the children in foster care to achieve permanency? So those are the 2 things that the data committee was really looking at during this meeting. And really, as the data committee continues to deep dive into the data from the CFSR on these 2 focus areas, the data committee will also continue to explore ways in which the court system, right? The court system and the judiciary can play an active role in ensuring that there are appropriate permanency goals and that cases are resolved in a timely manner, ensuring permanency for children. During our meeting, the committee had a really robust discussion about the multiple factors that could impact permanency, particularly for children with high acuity needs. And we had a really good conversation about that with our judges and those that were there at the committee meeting, and it was fantastic. Currently, as a preliminary matter, though, the committee discussed adding 3 to 4 questions as part of the pre-enrollment process for the October 2025 Child Welfare Judges Conference. So, and really, these are questions that are going to help us gather additional data so that we know how the various judges are handling certain issues related to permanency and permanency goals at their hearings. And so really the ability to include these questions related to the court's role in ensuring appropriate permanency goals and achieving timely permanency in this matter will really allow us to survey approximately 100 judges and provide additional data as the committee continues to focus on these areas for the upcoming year. So this is going to be something that we're really going to be focused on, and the additional data that we're going to get from these questions that we have it's been fortunate that we're allowed to do this is going to be really critical and very important. And the data committee is also closely tracking changes in the law as a result of the 89th legislative session, as everyone is. And really, we're doing that for purposes of what's going to be the trend analysis as a result of the legislative changes. And what can we learn from it? And then, of course, we've heard the word training. What training can we do as a result of that data? The data committee is going to meet again prior to the next commission meeting to further develop these projects for fiscal year 2026. There's a lot more that we still need to talk about, and a lot more that we still need to discuss to really hone in on a lot of these issues. But really the focus is going to be in, I think some of the things that Justice Huddle talked about, which is really the ensuring that quality of hearings, ensuring permanency, and making sure the goals are correct. Back to you, Jamie.
Thanks, Brenda. I know we have a couple members of our data committee on the screen as well, so thank you for your leadership. But does anybody have any feedback on the data committee at this time?
Or really any of the buckets. Really would love, welcome your feedback directionally.
And I just want to add in, is there anything that we missed? Not just, we're not limited to the things that we put forth. So Anne, please.
Sure. I just want to, Judge Sage and I are looking forward to continue to support the work of the commission in 2026. And as we have done in the past and this year, and look forward to working with you, Jamie, your team, and commission members on how best we can apply that support. So thank you.
Thank you, Anne. Judge Alvarado.
First and foremost, just thank you to everyone for the hard work that you've done on all the committees. I do have a question though, and it kind of correlates between the Legal Practices Committee and the Training Committee, as far as what efforts are being made to begin with the various schools as far as quality legal representation is concerned. Because I think that would be an invaluable resource to tap into, and then also provide proper training to facilitate more attorneys coming into this area of practice. Because one of the things that I think that we're seeing trending is that we have an older population of attorneys that practice in this area in Bexar County, and it would be really nice to utilize through clinics training of a younger group of that are going to be coming in as well. So I'm curious to know as far as what efforts are being made, and particularly both of those areas.
Excellent question. I'm going to ask Renee if she wants to answer.
As the first part, I know that with the Legal Practice and Process Committee, we have in the last year focused on trying to do attorney outreach. We've been working with TIDC, and as you know, they did those 5 videos that are available to show at law schools and at law school recruitment days with regard to why child welfare law. I think this is something that we're going to continue to support with TIDC's efforts to try to outreach. We're always willing and able to try to help in any way we can with regard to those who have training needs. I echo your concern about our aging legal community in the area of child welfare law. And so it is something that we're aware of. It is also something that, as part of a national group that I'm a part of, it's something that's going on nationwide. This is an area of law that just does not seem to be getting an influx of newer attorneys. So we're constantly trying to identify ways to reach out to younger attorneys to let them know about this area of law and to help support them through our training efforts. But any ideas that you all may have or any suggestions you have, we're always happy to hear about and to pursue as well.
Well, I have a follow-on question on the same topic. I think Judge Alvarado raises a really great idea in terms of not just outreach, but actually creating partnering with a law school to create a clinic. I mean, I from talking to kids who are applying to law school right now and visiting campuses, I know that one of their metrics and how they compete is and how they sell themselves is to say, we have this great experiential curriculum, right? Where you can go out and do a clinic on this, a Supreme Court clinic, a clinic on any number of substantive legal topics. I wonder, does anyone on the call have any reason to know whether any of the Texas law schools have a particular sort of individual or particular interest, so that we might identify and target a law school where there is already some interest brewing, and I would be willing to work a project like this and engage with a law school dean if anyone can identify a place where there is already interest in starting something up like this. I think it's a great way to create a pipeline of people and just generate some for a practice area that I know from when I was in law school was just not really much in focus at all.
So Justice Huddle, I started a child welfare clinic at Thurgood Marshall School of Law. It's been a challenge getting it off of the ground. So I am very happy to hear that you are willing to assist in that effort. If we could work together on that, that would be wonderful. I would love to have a meeting with you and the dean of the law school, because we had, for 2 years, we had pretty strong clinic, but then it's just something that's really hard to maintain if you don't have the foundational support. And so it's something that we're really excited about. The students love it. It's just structuring it in a way that there's sustainability. And so I think the planning of it needs to be more strategic. So I would love to discuss this further with you and anyone else on the commission that's willing to assist. Thanks, Judge Alvarado.
Thank you, Judge Graves-Harrington. Therese, I think your hand was up next, and then Judge Hoffman.
Thank you. Just want to add to that. I know that SMU has had a clinic for quite some time, and with really good success, particularly with aging out kids who have a lot of trouble, with certain documentation and sort of getting transition. I just want to echo the frustrating thing is that we have been supporting that clinic, and I'm nothing about SMU because we love SMU, but similar concern, the law school itself does not seem to have a real passion. And I know deans change and interests vary. And so I think the SMU clinic is in peril, but I think lots to learn there from just their experience if somebody's going to be working on that. And we shall see what happens.
Thank you, Therese. Judge Hoffman?
Yeah, thank you. I'm glad that Judge Graves-Harrington spoke up. I was going to mention that she's done the work that she was talking about, but also just mention that at NCJ-FCJ, we're actually moving into a program to have law school membership. So I think this is an area of national concern. Georgetown University in DC was the first NCJ-FCJ member. And so I think it's very interesting and hopefully something we can develop with all the law schools we have here in Texas. And also just highlight the fact that we work very closely with the clinic over at UT Lori Duke and her crew. So we already have that relationship as well.
So maybe, continuing the partnership in state and with national organizations who are looking to develop this additional capacity in the child welfare legal community. It's a great point, Judge Hoffman. Thank you. Okay. Well, I did want to also mention that you should have received the financial report, and that really just includes an update on where we are. As I mentioned earlier, we're through Q2 and going strong in Q3. So this is just a financial look. Unfortunately, Patrick had an emergency and couldn't be here with us today. So if you have questions, I will do my best to answer them. I'll pause for a minute and see if anybody had any questions about the financial update. Okay, well, with that, I just want to say we're so grateful to each of you. You bring so much expertise to these discussions. If you could, think on these ideas, see maybe what could be enhanced, what might need to change, what new ideas you have. We're still in that planning season, so please keep the ideas coming. Contact me directly or anyone on the team. We'd love to hear from you. But this has been a great discussion today. And as I mentioned, we'll come back to you in September and try to put it all together nicely into a proposed plan for the coming fiscal year. So with that, I'll turn it back to you, Justice Huddle.
Thanks, Jamie. So we are moving on to our next topic, but I want to just underscore what Jamie just mentioned, which is that your time to comment and think and continue to brainstorm ideas and strategies on these topics is not over. Please continue to give us your feedback by reaching out to the commission staff at any point. Okay, with that, let's shift gears and hear from the department. Today we have grateful to each of you for attending. Erica Bañuelos and Miss Tessera, did I get that right? Casey Tessera, to give us an agency update. So welcome, you have the floor.
Good morning.
I want to make sure. Go ahead, Erica.
I mean, at this point, I should know where the unmute button is at, but I don't. So good morning, everyone. I'm Erica Bañuelos, and today we are actually going to give the floor to Casey, who has been working tirelessly on the implementation of T3C. And I know that there's been some questions about, because we have a new CANS 3.0, that we used in the assessment of our children in order to find the best placement for them, but most importantly, to ensure that that the placement has the right services to serve the child. Casey has been working on this implementation. I know that she's come to the commission prior to implementation to talk a lot about the impact of this new model. And so we are happy to report that we've launched, and Casey is going to give us not just an update, but also talk about, some tools that her staff have developed for the courts, for the ad litem, so that we can make sure that y'all have all the needed information. So Casey, I will hand it to you.
Thank you, Erica, and what a privilege to be here today to talk to you about implementation of Texas Child-Centered Care. Many of you may have known this under a prior name of foster care rate modernization. I'm going to share my screen. I'm not going to go through in great detail because I have shared before with this group the model itself, but I do, just as a refresher, I will give a little bit of background on Texas Child-Centered Care. This is an initiative that has been going on for 6 years now, and we are, as Erica mentioned, in early stages of implementation. It is a complete transformation of our foster care system. The model that we use under the foster care system today has been in place for about 40 years now. Texas Child-Centered Care, or what we call T3C, has 4 main components that change. One is we have the CANS assessment. We've been using the CANS assessment since 2016 as a part of child welfare, but I'm going to talk a little bit today about the changes to the CANS assessment under the T3C model. We also moved to a system where we have clearly defined service packages. And those service packages are aligned to child need. And so rather than in your courtroom seeing a service level that a child has and understanding the components of the service level, under T3C, we'll have clearly defined service packages. And so there's a lot of detail behind those packages and understanding what the child is receiving that is in foster care in the way of services from the provider themselves. The other piece that is a major change under T3C is a new rate methodology. We have been using the same rate methodology since 1988 in Texas. The rates, of course, have changed over time, but the foundation methodology that supports foster care rates really is 40 years old. And so T3C moves to a methodological rate setting structure where these service packages have been quantified. And there's a new daily rate structure for foster care. And then the last component is an independent continuous quality assurance and improvement structure supported by the Texas Institute of Child and Family Wellbeing out of the University of Texas and Dr. Faulkner, which is going to come together, and not only with the department, but other stakeholders, youth with lived experience, parents, providers, members of the judiciary, help come together so we can keep the momentum going on improving the foster care system under T3C moving forward. It is, I won't go into this, but it is a multi-session, multi-year effort to get to the place of implementation under T3C. The legislature has been instrumental in directing the development of the T3C model and the new foster care rate methodology, and also in improving child assessment through the use of the CANS. Out of the 88th last session, we were funded and directed to implement the T3C system with the new rates and get the structure, the infrastructure in place to support this new system. We had about a year to get that done. We spent most of fiscal year 24 getting everything in place to be able to support this new system. In January, we met that milestone, and so we started a transition of children and providers to this new system beginning in March of this year. It is not, we don't intend to operate multiple systems for a long period of time, but it is not something that we can just flip the switch and everybody switches over. It is a complete change in business model for providers in the way that we operate foster care. So we have estimated that the implementation period will be about 2.5 years, and that all providers and children will transition to the new system in September of 2027. As a reminder, and you're familiar with this, under the current system, children are placed in under a service level. When they come into the foster care system, the vast majority of our children are served in basic foster homes and have a basic level of need. But for those with higher needs than basic, they are either designated with a moderate, specialized, or intense service level. The challenge with the service level system is it's largely focused on behavior. So as children are assessed for service levels, of course, a look at how their behaviors are manifesting really drives what their service level is, and then that's how we contract and place children. Under the new T3C system, it's a much more complex system than the 4 service level buckets that you're used to, because we will move to a system, or have moved to a system where providers specialize, they become credentialed and enroll to provide very unique services for children based on their needs. We determine what the child's needs are using a new version of the Child and Adolescent Needs and Strengths Assessment, the CANS, a 3.0 version. So all children under the T3C model that are 3 and older in care receive a CANS assessment. New to the CANS assessment, and I'm going to talk a little bit about this, is an algorithm that's not obvious to the child, not obvious to the caregiver, not obvious to the person administering the assessment, but an algorithm that behind the scenes, based on how the child, caregiver, and others that know the child respond to certain questions, identifies the optimal service package for the child, what we call the recommended service package. And that recommended service package aligns with one of the 24 service packages that you're seeing on slide 5 here. And I realize the print is probably very small for some, but we have 9 different service packages under the foster family home setting, 9 under a general residential operation tier 1 setting, and then 6 under general residential operation tier 2 settings. What this means is that providers that we contract with to provide foster care, whether it is as a part of community-based care, the SSDCs will follow the same process, or what's the remaining regions that haven't transitioned to community-based care yet. We will have common definition of services. We will have child placing agencies and foster homes that have unique training and knowledge and skill in administering care to children with based on varying need. In the general residential operations, we have a tier 1 setting and a tier 2 setting. The tier 1 setting primarily focuses on treatment services for the child. These are facility-based settings, but they are time limited in nature. There's an evidence-informed treatment model behind each of these service packages and for each provider, whether it's in foster care or a GRO setting. And so the child goes in a tier 1 setting and completes a treatment program and then steps down, hopefully home, or to a kinship caregiver, or maybe to a foster home. In the tier 2 settings, this is something that we have not had in our system before. These 6 settings, providers again become credentialed and specialize in providing this care, foster care providers. And these are stability services. So these services are designed for children who in our current system often are cycling in and out of psychiatric hospitals, having a really hard time stabilizing and regulating in treatment centers or foster family homes. And so these are considered stabilization services. They're even shorter in duration of stay than what is in the GRO tier 1 settings, all with the eye on helping children to improve their conditions, to improve, really treating the root cause of their trauma, their condition, and then being able to hopefully move to permanency, or if not, step down into a less restrictive setting. That's the foster care continuum. We have something called the T3C system blueprint that I just wanted to highlight as a resource for you. This is a technical guide. It was developed primarily with foster care providers in mind, but it's useful to, I think, all stakeholders working within the foster care system, because those 24 service packages that I showed, the blueprint outlines the expectations for each of those service packages. So if you wonder, if I order a child or somebody comes and presents to me that the child is receiving mental and behavioral health services in a foster home, what does that really mean? What is the child receiving? The blueprint will give you in great detail what that means, what the state is purchasing in the way of services for that child based on that particular service package. We release a blueprint every quarter. The component parts of the service packages don't really change from release to release, but this is a process where we are learning as we implement. It is intended by design to be an iterative approach, and we are making improvements. And so we release those improvements and updated details in the quarterly releases. We just released a version April the 29th. And so if you go to the link on this particular slide, you'll reach the April 25th blueprint. This is going over something that I indicated before. This is an example of a page for the mental and behavioral health support services in a foster family home. These charts are replicated by service package in that blueprint. You'll have information on not only the name, license requirements, but the service package description will tell you more or less what type of provider this is. And then it'll give you indications of, for this service package, this is the population of children that would benefit from the service package. There's service descriptions, all the things that are incorporated into the service package themselves, the anticipated length of stay by service package, staffing ratios, admission guidelines. One of the new pieces to T3C services that you may hear a little more about, or a lot about, hopefully, in your court is, with these service packages, there are aftercare services included in most service packages. This was something that was important to stakeholders as we were designing the service packages, to ensure consistency in care for children as children exit from one placement and move home, move to a relative, move to a different provider, having some consistency in care being able to do a handoff of information, keeping the child connected to the prior placement. All of that is incorporated in the aftercare services, and those are required. It's built into the rate. It's required of the majority of service packages. Another highlight for T3C services is that each provider has to have a trauma and evidence-informed treatment model. The state does not dictate what treatment model they have to use. That is up to the provider. But in order to deliver the service, they go through a thorough review, which we call credentialing, where they have to demonstrate competency, and that includes a presentation and answering questions and giving a good overview of the treatment model they've selected to meet the unique needs of children by service package. So not every treatment model is going to be the same. It really is supposed to be targeted to the service package itself. The other thing, just listening to some of the prior conversation that changes under T3C is providers now will have to have, foster care providers will now have to have policies and procedures under T3C that are directed to family engagement. So making sure that they have policies and procedures for outreaching to the biological family of the child when appropriate, to kinship caregivers, to those that are really important to the child. All of that has to be in the policies and procedures that they submit to the department to become credentialed to provide these services. So we should be able to see a lot of improvement in the family engagement area for children that are in foster care through the delivery of that piece. I talked about the CANs. As I mentioned before, we've been using a version of the CANs in the welfare system, the child welfare system, since 2016. Here in Texas, it was called Texas CANS 2.0 before. We have a new version called the 3.0 version. It has been specially developed by Dr. John Lyons, who was the creator of the CANs, to help align with this T3C system. So it is a CANs version that is unique to our state and to our system moving forward. It is the CANs, of course, itself is an evidence-based trauma-informed multi-purpose tool. But one of the things that is unique to this CANs in particular is Dr. Lyons and his team have taken each of the 24 service packages and determined, using the instrument for CANs, how children would align with those service packages. So there's an algorithm behind the scenes that, as the child is assessed, then generates what's called a recommended service package at the completion of the assessment. The CANs itself is still used as it has been and will continue to be to inform service planning, but it kind of incorporates it into the foster care arena for foster care providers to start really using the CANs as the basis for a lot of their service planning development. It is one of the things that we're going to use to inform placement decisions around where children should be placed and what service package they align to. It is different than the service level system, however, in that it is not the ultimate determinant. This tool is not determining in place of the caseworker and in place of the attorney and the guardian and the court where the child should be placed. It is simply a new tool that we have not had before that helps to inform that decision. Understanding how the child what it looked like on the CANs and what the recommended service package is just one part of the overall decision of matching a child to a placement. Also different under T3C is moving the CANs, streamlining the CANs and moving it under one system. Children in care today under the service level system are assessed using the CANs by Star Health annually and initially when they come into care. And then if they're served under community-based care, and they're receiving therapeutic services, then the SSCCs also administer a CANs. And then if they're receiving behavioral health services through like the LMHA, they're receiving a CANs assessment there too. It was a lot of CANs. Children are telling their stories over and over. And so as a part of T3C, we're trying to streamline that and bring it into one place where the assessor themselves have access to not only the child, but to the child's family, to the caregiver, to the child's attorney, to the school, to bring information together and get a much more comprehensive and robust assessment than we've ever had before. And in order to make that change, we have new CANs assessor staff out of last session that either are employees of the SSCC or in legacy areas, the DFPS system. And those CANs assessors have been trained to administer this tool with children with the goal that they will follow the child through the system. So instead of the child having to move and be assessed over and over again by different CANS assessors and retelling their story, the goal here is to have the same CANS assessor administer the reassessments over time. But this is something that is going to take time for the system to shift. We have started training staff, we have trained providers, we have trained other stakeholders in the system, but making the philosophical shift and using the CANS in service planning in this way is something that we are going to continue to improve upon and learn from. We have some tools and resources, as Erica mentioned earlier, that are available to the public. We have a series of videos. These are some really cool videos that some of our youth in care and young adults helped inform, because our children in care don't understand the CANS either. They just know that they're answering questions. And so we've developed a series of YouTube videos that are designed, depending on what your role is in the system, to help explain what the CANS is, why we use the CANS in the way that we do, but from the perspective of a young child, youth, young adult. We're using this information, or the new CANS assessor staff are using this information as an icebreaker with children when they're administering the CANS for the first time to them, so that they understand the process and are more informed, and with youth and young adults as well. We also have a video for foster caregivers or kinship caregivers, both in English and Spanish, to help them understand the CANS better and what the CANS is used for. We have a new thing that was released with judges and members of the judiciary in mind, which is an online training. It takes about 15 to 20 minutes to complete, and I've linked it here. And it is on how to read the ECANS report, because that was some of the questions that we got back, is folks get the ECANS, the CANS assessment on a child, and don't really understand what they're looking at and how to read it. So Dr. Lyons has also put together this new resource that we hope you'll review and provide feedback on, that is supposed to be helpful on how to read the ECANS report. New to the CANS 3.0, and as you see this, we also have included a comparison chart that helps to assess child progress between CANS assessments. So children receive CANS assessments multiple times. Some are quarterly, some are annually. It just really depends on the services that they're receiving and their service package. But it allows for a quick review of the progress they've made between the prior CANS that was administered and the latest version, and really helps the team that's working with the child to identify the areas of greatest need so that they can design services around that area. And so that is something that is brand new with this latest CANS 3.0 version. I've mentioned a little bit about providers enrolling and qualifying to provide CANS. You're going to hear a little bit probably about credentialing. So it's not a flip of the switch. Not all providers in the system just elect what they want to provide, and then we say, go forth and provide the process. As a part of T3C, we have started a new process at the department called credentialing. And providers that want to move to the T3C system have to apply to the department through this application process, and they have to be able to demonstrate through an enrollment process that they meet the qualifications to provide these quality foster care services. Once they make it through the credentialing process, they're issued a credential by service package, and they're able to then contract with any SSCC or the department under the legacy system to provide those service packages. So that is a new process for us, and that's where we are with providers right now. We opened up that credentialing process in December. We had our first providers become credentialed. The first 2 providers became credentialed in February. And then in March, we started having children transition to the system with those providers that had become credentialed. As of yesterday's date, we had more than 110 providers that have submitted applications to become credentialed under T3C. 19 of those providers have been awarded now what we call their active credential. We have about 14% of the children in foster care today that aren't currently receiving one of the 24 T3C service packages, and another 26 providers that are finishing up the process and should be transitioning very soon over to T3C. I have linked here on slide 11 at the bottom. If you're interested in who those providers are, what part of the state they serve, and what service packages they offer, we have an updated list that we keep current at link there on slide 11, where you can see who those providers are. I thought it would be important maybe to this group to just show for those 14% in the where they're placed, what service packages they're aligning to as their selected service package currently. You can see that 61% are in basic T3C basic foster family homes. So of that 14% of children that have transitioned out of foster care into T3C, 61% are receiving basic foster family home services. 22% are in a foster family home receiving mental and behavioral health service package. And then we have about 4% receiving complex medical services, about 5% are receiving treatment foster care services, and then there's an 8% in that yellow that distributes out the children that are receiving services through a general residential operation setting. The biggest area there is mental and behavioral health services in a residential treatment center. So of the children that have transitioned, 92% have been able to stay in a foster family home setting. That's what's been identified as their selected service package, with 8% in congregate care. And that is representative of those 19 providers that have moved over, which represent 14% of the children in care. So that's a lot of numbers. Sorry, but I think as you look at it, you'll be able to digest them there. We do have a mailbox open for questions, and some of you on the call have been submitting questions to us, and we appreciate that very much because we man it every day. We respond to those questions. It helps us in understanding the experience of folks that are living this every day and where we need to focus our efforts. It also helps us to generate frequently asked questions, which we post on our webpage. And we also have a distribution list. So as new service blueprints come out, or as we have new things to share about the provider base and that kind of thing, we have a distribution list that we would invite you also to either sign up yourself or have somebody sign up for you that would just notify you that something has changed with T3C. We've released a new blueprint, but it will help you to stay current on our progress with implementation. I know that's a lot of information to cover in a very short time, so I welcome any questions that anyone has as we move forward.
Easy question for you. Hopefully, we had a request in the Q&A for the PowerPoint. If you could share that with us, we'll put it up on our website.
Yes, ma'am. Yes.
Thank you so much.
I have a question about how, I saw that you included a link there so that anyone on this call could watch a training video about how to understand the report that the T3C model generates about a particular case. But do the judges know, have access to that resource? How, when something like this is changes underfoot at the department, how is it that the judges with boots on the ground actually learn about it? How are they informed? What is the actual communication flow other than sort of the commission meeting and having trainings? How does the right hand know what the left hand is doing?
We have been, that's a great question. We have been, of course, engaged with the commission, but you said outside of the commission. We have had certain judges that have reached out to us, and we have offered training individually to different judges that have, at this point, Judge, it has been at request. If they have requested the information, we have tried through distribution lists and other places to also share the information. It's been a process. I mentioned before that last fiscal year, we spent most of the fiscal year building out the infrastructure to support the new system to get to January. And so trying to figure out the training, we didn't want to train folks too early on it. Because then you lose that knowledge before they are able to actually start seeing the system in play. So we started training our staff and the SSCC staff in November and December and have ongoing office hours and trainings with them. But I think that is one thing that we would be really interested in, any feedback that folks have. It is a big change for the system. And so we want to make sure that everybody, in particular the judges that are hearing these cases and working through this, have access to the information. I think we're now at the place to be sharing that information with the percentage of children that have moved over, and getting everybody really comfortable with understanding the change in the new system.
Yeah, I don't know. I'd like input from Jamie or the judges. I see that Judge Susan Brown is on here. Is this something that, you know, that ought to be sent out to the regional judges and then cascaded down to every judge who hears these kinds of cases? I mean, it seems like the kind of thing that we need to be systematic in communicating about, not just leave it to people to ask a question on their own, you know, of their own volition. So I think a systematic communication makes more sense here. I don't know the best way to accomplish that.
We do address this issue at the annual Child Welfare Judges Conference, but I think you make a great point that a more concerted communication and maybe more than one time would be in order. And so we'll explore that with Casey and make sure that the information is digestible and that it helps people get to the right place to answer their questions or to know who to ask.
Or Anne, you have a question or comment?
Just a comment, Justice. So I've been around the department in leadership roles over the decades. And, you know, when the previous rate reimbursement system was in place, I think probably, Casey, you were probably in kindergarten. It's been a long time. And I really have to congratulate the department and the Texas legislature, because this has now become a national model of how to do it right and how to meet the needs of children. You know, the old system Casey mentioned was behavioral based. Well, you can see providers would struggle with, well, if I accelerate my description of the behaviors, I'll get more reimbursement to meet the needs of the child, but that doesn't necessarily mean the service package was. This is just a game changer. It really is. When you look at the independent assessment, when you look at the quality follow-up, when you look at the service packages that are child-specific, post-care, engaging families, this really is a national model, and the department and the Texas legislature really needs to take a bow. This happened against all odds. And Casey, you hung in there, and the leadership of the department, thank you, Audrey and Erica, for making it happen. It's complicated, but it will advance best care for children substantially. So thank you for being on let me be on my soapbox, Justice.
Thank you, Anne. Always happy to hear your encouraging feedback. Any other questions or discussion? Yeah, Gary.
Just quickly, Casey, as part of this process, is there a mechanism in place for feedback from, like, whether it's from the John Lyons and his group, or, you know, for basically outcomes that are going to be? Because I think that I'll echo the idea that this is, you know, really important and next steps. And I think if we have data to show that this system has impacted outcomes in a positive way, then that would really go far to continue and to expand.
Yes, sir. That is a very good question. Another part, at the provider level, they will have to collect their own data and have their own CQI processes, and we will collect information that way. So we'll understand it at the very provider level. But from a systemic perspective, that's one of the things that the Texas Institute for Child and Family Wellbeing is going to help us with, is collecting the information so that we have a sustainable structure. We started with these 24 service packages. That was based on a data analysis of what children's needs were at the time that we designed the continuum of care But to your point, we want to make sure that it is correct in those service packages, that they're reaching the intended outcomes that they were designed to reach. And so that's part of having this independent kind of third party that is helping to look and look at the evaluation of the service models of the system. How's the CANs working? And is it aligning the way that we need it to? And not to scrap and start over, but just to make the adjustments that are needed along the way. We don't want anybody 40 years from now to have to come in and overhaul the entire system again, because it's been a big investment, as Commissioner Hilgenstein said, to bring forth. We don't want to do that. We just want to keep advancing and improving upon what we've built to meet the needs and the ever-changing needs of children and youth. And so that's the plan at this point, is to use that structure to look at that information and then work with all the system to make advancements in the model.
Thank you. That's great. Will there be a commensurate sort of movement in terms of licensing activities within the state for those different categories, or are these just going to be contractual?
So we have in each of the service packages, as you go into those charts that I showed, it says what permit type it has, the provider has to have to offer that type of service, and then there's permitted services. That was the foundation that we started when we started building out the service packages. What's already required of providers in minimum standards, we quantified that into the rates, and then some of the other things that are above what are in standards. It should not change licensing requirements. However, there is an effort underway in the state, as you probably know, to look at minimum standards and the regulatory function of HHSC. We now have a system where we can adjust. If the minimum standards change, we'll be able to go in and adjust the requirements under T3C, which is not something that would have been easily able to do under the service level system. So that is also an advantage, is we have very clear methodology on the rates.
Thank you.
Thanks, Casey. Judge Grace Harrington, did you find the answer to your question? Because I think your hand was up and now is gone, but we have just a couple more minutes before we need to move on to the next speaker if you have a lingering question.
I did not have a question. I just wanted to also chime in and say that I am really excited about this and the requirement for the family engagement. At the beginning of this meeting today, we talked about, the steps that we could take towards family reunification. And this is really huge. It's really about the family engagement and holding everyone accountable for doing their part in ensuring that these families, these children, and these parents, as safely as possible, remain in contact with each other. Looking towards the goal of reunification. So that's all I wanted to say. Thank you.
Well, thank you. And if there are no more questions, what I'd like to do is give a very big thanks to Casey for the presentation today, but also all of the work and tremendous thought and care that has gone into revamping such a big sort of fundamental part of the system. We appreciate you and your work, and we're excited to see that the continuation of this rollout, and also encouraged that you are thinking not just about starting this in 2025, but about how it will need to continue to evolve for the life of it, and in terms of collecting data to figure out as we go where course correction is needed, and whether outcomes are improving. So well done, bravo. We'll look forward to seeing how this unfolds. Glad also for your time and presentation here today. So thank you, Casey and Erica. We'll switch gears now to hear from Jeff Tsunakawa from OCA, Office of Court Administration. Jeff, I don't know the particulars of what you're presenting, but I am looking forward to it. Go ahead.
Thank you, Justice Huddle. I am here for Megan Lavoie, our Administrative Director. These days, Megan is often in 5 places at once, so she sends her apologies that she can't be here. Legislative session is a very busy time for Megan and the entire agency. So we're doing the best we can to cover. I'm just going to give some brief updates. I know there was a request for some highlights in legislation that might be applicable. And then I want to wrap up with just a couple of highlights on our budget and some of the work of our child protection judges. We are very close to nearing the end of session. For statistical highlights, there have been a total of 9,194 bills filed this session. That is a record number. And for comparison, last session there were about 8,000 bills, and the prior session about 7,000. So we have seen an increase in the number of bills that have been filed. All bills are required to have a fiscal note. The Comptroller's Office receives all requests for fiscal notes, obviously, but the Office of Court Administration receives the second most requests for fiscal notes for all bills filed. So we've done well over 2,000 fiscal notes, which accounts for almost a quarter of all bills that have filed. That means a quarter of all bills that have been filed in one way or another affects the third branch of government. And so we take a look at all those bills and determine if there's any fiscal impact that the legislature should be aware of. We're watching many bills even still. There are several bills regarding judicial pay, judicial accountability, increased security and privacy protections, bail reform, and many more. Many of you probably were aware of the governor's bail roundtable press conference a couple days ago. The last day, next Thursday is the last day for bills to be heard by the House. And if they're not heard by the House, they are potentially seasoned to die this session. The last day of session is June 2nd. That's a key deadline. June 22nd is the deadline for the governor to veto any bills that are on his desk. And just a reminder, last session, there were 4 special sessions called. So even with the conclusion of session on June 2nd, it doesn't mean that session is necessarily over. There are just a few bills out of the hundreds that we're still keeping track of that I thought this group might want to be aware of if you're not aware of them. HB 2216 by Representative Hull, I think is referred to as the Active Efforts Bill. That was passed by the House 140-4. It was heard in the Senate Health and Human Services Committee a couple of days ago on the 7th. So that's making good progress. HB 3783, also by Hull. It's regarding mandating counseling and the training and background of mental health professionals. That was passed also by the House 143-0 and referred to Senate jurisprudence. House Bill 1151, also by Hull. That's regarding neglect clarification for treatment. Also passed the House 145-1. It was heard in Senate Health and Human Services yesterday. HB 3181 by Representative Dutton. We refer to that one as the Child's Best Interest Bill. That passed the House 135-6, and it was referred to the Senate State Affairs Committee. And then Senate Bill 1398 by Colcourt regarding orders for temporary emergency care when there's suitable placement available. That passed the Senate 31-0 and was also in the House and Health and Human Services Committee yesterday and was heard. I think the commission is probably much more familiar with a lot more bills that are affecting this group. But those are 5 that we're definitely in conversations with and keeping an eye on. All those bills are making great progress. Even while we've been in this meeting, there have been many committees that have been scheduled for next week. So as those deadlines come up, there should be a flurry of committee hearings being scheduled, resource witnesses testifying, and movement on bills. When session is over, like many agencies, we will definitely do a very comprehensive summary of what passed during session and report that out. So look forward to that at the conclusion of session. We want to highlight a couple of items that have really been favorable in our budget. We requested 11 data positions. We call those our regional data coordinators. And at this point, it has been, it's included in both the House and the Senate budget. These positions would be assigned to each of the 11 judicial regions across the state. Their duties would be to work with the regional presiding judges, clerks, judges, and help increase reporting. We've probably mentioned many times about case level data. We are in a phase of going from collecting aggregate county data about courts to collecting case specific data on every court. We have signed a contract with Tyler Technologies to build a data warehouse to collect all that data. But what we're finding is from county to county, courts and clerks are finding reporting issues, whether the clerk or the judge believe that the data is the same. Systems aren't programmed correctly. So we're seeing a lot of data cleanup needed. So these positions will be there to help make sure that data is clean and reported accurately. We also in the House and the Senate budget, we requested a statewide case management system for specialty courts. So that would be inclusive of the statutorily defined courts, your drug courts, your juvenile drug courts, mental health courts, veterans treatment courts. There's about 208 of those defined courts across the state. For years, those courts have requested from our agency a statewide system for them to use to track data and outcomes for the defendants that go through these special programs. In many of our counties, these courts operate through Microsoft Excel collating information. So there's really not a good standard way to track data and see and track outcomes. So we are very close to seeing that pass the budget, and then we'll work post session to procure that system and implement that system statewide. Megan also wanted me to mention we have launched our program called eCourt Date, which is our state-funded text reminder system. This was a legislative initiative that was assigned to us. You're probably familiar with the systems that your doctor's office uses to send you reminders when your cleaning is coming up or your other appointments are coming up. So this is the same concept for people in their court hearings. We have 2 counties that have joined the system so far, Tarrant County and Cameron County. As of today, between those 2 counties, they've issued 1.5 million text messages. So it's been a successful program for those jurisdictions, and we have 40 other counties in the queue to implement the system. The text reminder system is a free of charge system. The counties just have to integrate it with their case management system. We are also in the middle of implementing HB 2384 and HB 1182 from last session. Those bills were specific to courts reporting on caseloads. 1182 requires counties over a population of 1 million to report on a monthly basis very specific data points. So that's Harris, Tarrant, Dallas, Bexar, Travis, and Collin. And then 2384 is a very important bill and very sensitive bill to courts. This is a performance measures bill where we are looking at 3 data points for every court in the state. So we're looking at clearance rates, the age of active pending caseload, and the age of cases dismissed. As we collect that information, the presiding judges are reviewing it and determining what the performance standards of acceptable and not acceptable are. So we have posted 6 months of data for all the courts from March to August of last year on our website. The next report will be published in November for all the information, all the data up to that point. So if you're curious, the 6 months of data that I referenced is on our website now for every court. Wanted to wrap up with some updates that are specific to our child protection judges and our child protection program. Many of you are probably familiar with Judge McClanahan. Judge McClanahan, good for her, sad for us, retired at the end of February. We're very fortunate that our child protection judges generally stay with the agency and stay with their jobs for a very long amount of time. So we don't see a lot of turnover in our judges, but Judge McClanahan reached that point of retirement. So we're thrilled for her. We have hired Jessica Devaney. She is now the new associate judge for the Child Protection Court in Central Texas, and is off to a good start. We are continuing to work with the Children's Commission and the department on the Early Intervention Court Liaison Project. That was a joint project, hiring 3 liaisons to work in our courts in Galveston, Galveston, Bell County, and the Lubbock area. That grant project is the grant is set to expire at the end of August. We are working actively with the commission, the department, to find ways to sustain that work going forward. Judge April Prost, one of our CPC judges, received the Heart of the Champion Award at this year's Champions for Children's Conference back in March. Judge Prost is a very active judge, and we're very proud of her for receiving that award. And then, too many to name, but our judges spend a lot of time working their cases and their dockets, and they spend a lot of extra time educating lawyers and the public on child welfare at many conferences, the Child Protection Law Conference, UT events, just too many to name. But I did want to make sure that you knew that our judges are going far and beyond their judicial duties to make sure that the public is educated on what they should know about in child welfare law. Just so those are very brief highlights of what the agency is doing and has been doing, but I'm happy to take any questions.
Thank you, Jeff. Really good, thorough report as usual, and right on time. We appreciate your being here with us. Thanks for all of the work that you're doing. I know session is a mountain of work for you all, and we applaud what you're doing, and happily say that you can see the light at the end of the tunnel here.
Yes.
With the end just a month away. Thank you. The last thing on today's agenda is to hear from Barbara Elias Percival, who I see is on the screen now. Barbara's a collaborative council member, and she has an announcement for us. Barbara, I should have said, is with Texas Lawyers for Children. So Barbara, go ahead and take up to 2 minutes for your announcement. The floor is yours.
Thank you, Justice Huddle. And before I give you my announcement, I just want to say a moment, Justice Huddle, about your question about getting the word out about T3C. Want to let you know that one way we support the Commission's work is to make announcements. We operate an online legal resource and communication center for judges and attorneys handling child protection cases. And there's over 3,800 judges and attorneys participating in that. So we do mass emails and send out word. And on this particular issue, Casey was kind enough to do a webinar for us on implementation of TC3. So we have that recording, and we can let people know that they can see it there too. So that is one way to get the word out. What I wanted to announce is that, as many of you know, our organization developed a legal professional trauma training program. It's 15 hours long, and it's very comprehensive. And all of the hours get family violence continuing judicial credit. And so it's been going on for several years now, and we've trained over 1,600 judges and attorneys and other stakeholders about the impact of trauma on children and how judges and attorneys can help children get the things that they need to heal from the trauma. And so we want to follow up now with all that training and see what's happening out there in the field because of the training. And so we're going to have 3 different dialogues, one for judges, one for attorneys, and one for CPS and CASA and other professionals who've taken the training, called From Dialogue to Direct Action. The one for judges is how a trauma-informed judiciary can lead system-wide change for children. There's a flyer about it as the very last page of your notebook. And what we want to discuss in this dialogue is what's changed because of an awareness of trauma in the field? What are people doing differently? What are the barriers in trying to create a more trauma-informed system than we already have? And there have been so many improvements in that way. So we're happy about all of that, but we want to see what's going on now and any ideas people have. So there's still the one for judges. I'm happy to announce that Judge Graves Harrington is going to be the facilitator for the judicial dialogue. That's going to be June 5th at 4:30, Thursday, June 5th at 4:30. And there's a link at the bottom of the flyer where you can sign up. If you want to participate in the dialogue, it's only for those who have gone through the trauma training course, but there's still time to take the course. And also for this dialogue, if you just register and show intention of taking the course and you want to hear ideas of how people are changing their courtroom practice, you can just register for the trauma training and then register for the dialogue, and then you can participate and hear new ideas. To register for the training, go to texaslawyersforchildren.org and you can register there. There's a trauma training portal with the link on the homepage. So it's very easy to find, and I hope you'll participate in the dialogue. And we're so grateful for Judge Graves Harrington to be facilitating this. One other thing we're doing is training for new attorneys in the field to help support those who are coming into the field. It's called Tricks of the Trade, and our next training in that program is going to be June 18th on evidence and how to introduce it and strategic ways to use it. Thanks for the time.
Thank you so much, Barbara, for the announcements, and thank you to Judge Grace Harrington for going the extra mile to get that training, that conversation facilitated. Two more things I'd like to do before we sign off for the day. I'm mindful that it is that it's 11:30 on the nose. One is to say that to remind that our meeting schedule, our next meeting will be Friday, September 26th. That'll be in person, and then we'll close out the calendar year with a virtual meeting on November 14th of 2025. That's thing one. Please mark your calendars if you haven't already. Thing two is I wanted to sign off by saying thank you for joining, thank you for participating, and continuing to think about these challenges and opportunities to continue to improve our system for families and children. Happy Mother's Day to any mothers on the call. And also, if you have any graduates, happy graduation to them. I hope each of you has a great rest of the day and weekend, and I'll look forward to seeing